Now, can I ask this of the whole panel? And this comes back to some points which are already raised, that courts emphasise finality as a core legal value. How can a review body be designed to prioritise accuracy and reliability of their review while still respecting that fundamental need for legal certainty in court outcomes? Of course.
Look, yeah, finality is definitely a legal position, and I'd always take accuracy over that. And I guess one way in hearing the presentations, thinking about it as well, is, if we keep things interdisciplinary, if we keep, the legal aspects for those professionals and the lawyers, but then bring all the other experts in too. Bring all the other expertise, because don't you want the best in the room to kind of get at this issue, to get at that accuracy and that reliability, is what I would say. Simply.
Okay. I'm going to answer for both of us then. I think we're all in here in the room today to be thinking about people like Terry and Kathleen, who are the victims of miscarriages of justice. But there are also other victims, those that lose their loved ones, albeit not to the person that might be convicted of the crime. So there is a need for finality for the broader society. There's a good reason to have finality, but there's even better reason to have a really flexible standard when you are looking at cases that there is doubt about a wrongful conviction, because we treat finality in terms of preserving the court's outcome as the gold standard, but really we're doing ourselves a disservice by saying, oh, it must be, the jury got it right, the judge got it right, when we really ought to be thinking, okay, things are evolving over time, and not relying, like you said, Gary, and I cannot stress enough about the whole, science-free Kathleen, and let's just sweep under the carpet or the 20 years of rubbish they did to you. But we also, I think the way to do that too is by having a commission that has multi-levels of review again. I think that's really important, because that then fosters a bit more of an open mind if there are multiple people looking at it. But yeah, in terms of, I think it's the old adage by Blackstone, isn't it? Better than 10 guilty persons walk free than one innocent person suffer. I know that's probably a little bit decontextualised now, but I think that that's the principle that we need to apply to post-conviction review as a culture in any institution.
Oh, yeah, look, finality, or the finality principle, is just that. It's a principle, one of many factors that allows our justice system to continue. It's a bit like the secrecy of the jury room. But if that is flawed, that is the finality as at today, it's valuable that we, for the good of everybody, that we finalise this case and everybody gets on with their lives. If there is a major, as Rhanee was saying, if there is a major discrepancy in the evidence, a CCRC is able, because the model that we've been talking about today has investigative powers, that is de novo reassessment of what's going on, they will be able to look at those intervening matters. And in that case, the finality principle really becomes otiose. It is really the new facts and new evidence that will make for the decision whether the case is reopened or sent back for further appeal or whatever. So it's just, finality principle is just one factor that one has to take into account when considering the changes in facts as they occur over time.
And existing appeals, of course, presume the existence of potential argues in process. Yeah, well, it's tied up with the fresh evidence rule, and I won't go into all of that because it's been well handled today. But presumably the CCRC will be able to look at fresh evidence, providing that it's still admissible or still available, I should say. So those sorts of things, I think, will overcome some of the more difficult hurdles that wrongly convicted people face. I mean, yep.